extent of powers of the Chief Election Commissioner and the Election Commissioner, there is no dispute.
No, but the length of power, my lord, after disqualification for what period, it is to be on the advice of the Election Commission. So, my lord, it definitely depends, my lord. There are cases where, my lord, for corrupt practice, somebody is disqualified and his period is reduced to, my lord, 5 days, 10 days, he again becomes the Chief Minister.
Nobody is disputing that. Must realize that the Chief Election Commissioner cannot be removed from office except in the manner the Supreme Court judges.
Please, your lordship.
So that gives a clear indicator.
That you cannot leave it to the person, my lord, who will appoint him and then he feels obligation for his lifetime and he feels indebted. An independent person cannot be biased. The matter regarding conditions of service of the Chief Election Commissioner, other Election Commissioner, the procedure for transaction of business of Election Commission are presently governed by the 1991 Act. The said Act do not contain any provision regarding qualifications, search committee for preparing panel of persons for consideration and recommendation of selection committee for appointment as Chief Election Commissioner, other Election Commissioner, and other incidental provisions. The Honorable Supreme Court in Hon'ble declared that the appointment of CEC and EC shall be made by the President on the basis of the advice tendered by the committee consisting of the Prime Minister, Leader of Opposition and the Chief Justice of India. It has been clarified that the aforesaid judgment that the said norm provided by the Supreme Court will continue to hold till a law is made by the Parliament. The proposed bill inter alia provides for defining various expressions in the bill: appointment, qualification, search committee, selection committee, term of office, salary, resignation, removal, pension of Chief Election Commission, Election Commission, and transaction of business for disposal. The bill seeks to achieve the aforesaid object. That's all. But it does refer to the judgment of your lordship, Lord, in Hon'ble case. I was inviting your lordship's attention to the debates, my lord, just page 19, my lord, also.
Debates now, after having gone through.
Yes, my lord.
So much light.
All the said, my lord.
In fact, I have been shown by my learned brother certain portions.
Yes, my lord.
Which leaves a very bitter taste in the mouth.
Yes, my lord.
They are of no help.
I will not go. All that it says, my lord, that there is no change. Effectively, there is no change. It is the.
They are of no help to you.
Yes, my lord. Very well, lord. I lordship wanted me to read this, lord. I just read this. Now, my lord, I wanted to show to your lordship, my lord, from
a written submission
in volume 1, my lord, the extent of power of the Election Commission. I have made a chart there, my lord. If your lordship come to volume 1, please.
Perhaps there is no dispute on that.
I'm sorry. My lord,
Extent of powers of the Chief Election Commissioner and the Election Commissioner, there is no dispute.
No, but the length of power, my lord, it is.
Already told us that this
I have tabulated it. If your lordship just permit me to just place it, my lord, hurriedly. I have tabulated certain. First, my lord, page 13 to 16, there are certain advisory powers.
Right.
To the President. The page 13 to 16, there are advisory powers to the President, my lord, regarding disqualification, holding of office of profit, etc. Then similarly, my lord, in the RP Act, regarding delimitation also there are powers. My lord, what is important is, my lord, page 14, serial 5, disqualification on corrupt practice. If I can read, my lord, section 8A, even after disqualification for what period, it is to be on the advice of the Election Commission. So, my lord, it definitely depends, my lord. There are cases where, my lord, for corrupt practice, somebody is disqualified and his period is reduced to, my lord, 5 days, 10 days, he again becomes the Chief Minister. So that power is there with the election. I'm just going with the width of the power of the Election Commission.
Nobody is disputing that. Must realize that Chief Election Commissioner cannot be removed from office except in the manner the Supreme Court judges.
Please, your lordship.
So that gives a clear indicator.
Lord, what I have.
We need not labor on that.
No, all that your lordship may know, Lord, I have categorized them in 5 categories. There is advisory power, they have a legislative power, they have supervisory power, they have quasi-judicial power, and they have administrative power, my lord, which I have tabulated in this under 5 different heads, my lord. Because in the symbol order, my lord, they have very extensive power regarding symbol, disqualification, which party to be recognized splinter group and which party is not to be recognized as splinter group, my lord. What your lordships have laid down the guideline, my lord, that you cannot leave it to the person, my lord, who will appoint him and then he feels obligation for his lifetime and he feels indebted. An independent person cannot be biased, holding scales openly even in the stormiest of times, not being servile to the powerful, but coming to the rescue of the weak and wrong, who is otherwise right, would qualify as true independence. This is the test, my lord, whether we have a system which selects a person who is not obliged to a person. It may be true, my lords, about it, that the Election Commission of India provides its services to certain countries. That, however, does not deflect this court from providing what its founding fathers contemplated and also advocated in various reports. It may be true that the Election Commission of India were appointed for the 4 decades of the Republic and thereafter. Since the year 1993, Election Commission has become a team which consists of Chief Election Commissioner and 2 election commissioners and the 2 election commissioners. It may be true in the sense that the President, acting on the advice of the Prime Minister in accordance with the rules of business concerned, has been making the appointment. However, it is equally clear that Article 324 has a unique background. The founding fathers clearly contemplated a law by Parliament and did not intend the executive exclusively calling the shot in the manner of appointment of the commission. This is what your lordships have found in the Constitution bench. 7 decades have passed by. Political dispensations are varying use, which have held the reign of power, have not unnaturally introduced a law. Could not be one to perpetuate what is already permitted, namely appointment at an absolute and sole discretion of the executive. A law, as Mr. Gopal Singh Karnan pointed out, would have to be necessarily different. In the absence of such a law, does create a vacuum. This is despite the chorus of the voices, even cutting across the political divide, urging divesting of the exclusive executive of the appointment from the executive. We have noticed that the making of a law is ordinarily the power of the legislature. Lordship may exclude that. Come to 303. Political parties undoubtedly would appear to betray a special interest in not forthcoming the law. The reasons are not far to seek. There is a critically vital link between the independence of the Election Commission and the pursuit of power, a consolidation and perpetuation. As long as the party which is voted into power is concerned, there is not unnaturally a near insatiable quest to continue in this saddle, a pliable election commission, an unfair and unbiased overseer of the fundamental exercise of adult franchisee, which lies at the heart of democracy, who obliges the power that be, perhaps offer the surest gateway to acquisition and retention of power. But what can be the more blunt way of putting it, my lord? That they have an interest. The values that animated of the freedom struggle has to be brought to the home by a new generation who has come to the inspiration relating to fundamental duties. Criminalization of politics, a huge surge in the influence of money power, the role, and lordship would, when it criminalization of politics, my lord, lordship would note, my lord, 40% of our lawmakers, be it parliament, be it the state legislature, have criminal cases.
26.
And this court, my lord, despite taking various steps, my lord, have not been able to reduce that number.
Not the subject matter.
Yes.
It's confined to the subject.
Yes, my lord, very well, my lord, may read it.
Tell us, after saying in various paragraphs the need
Yes, my
to
lord.
exclude the executive, why is it said in 315?
Yes, lordship would sign the final name, lord, in 320, para
The
326.
court is laying down norms.
Yes.
Laying down norms for what? Appointment of
Appointment of
election commissioner?
Yes, my lord.
Why does court restrict it only for a particular period till the law is made? The
Till-
court could have stopped
till-
at 314.
Yes.
They are asking you what was the reason that wait in the
No,
mind
because
of
there
the
was no
court?
law at that point of time.
There was no
Till a
law.
law is made.
There was no law.
Yes,
The
my
court says that there is a necessity
Vacuum?
to bring in a law.
Yes, my lord.
The court is discussing, if you
Yes.
see Mr. Ansaria,
Yes, my lord.
309.
Please, your lordships. 309. In a unique provision of person, we are concerned with the devastating effect of continuing to leave the appointment in the sole hand of the executive or fundamental values as the fundamental rights, as we are also considered of the time the right for the court to lay down the norms. In other words, the vacuum exists on the basis of that, unlike other appointments, it was intended all throughout the appointment exclusively by the executive was the mere transit or stopgap arrangement. It was to be replaced by a law made by the parliament, taking away. Now, the law is to be, my lord, taking away the exclusive power of the executive. My lord, this is what your lordship has said. Whether the law meets this test, whether the law has taken
Therefore,
over,
the court finds that it is high time that norm should be laid down.
and it should not be in the hands of the executive alone.
So then why is it said in
315, my lord, that the law will be made, my lord. But law has to be, such law has,
you say that the basis of the order of
Yes.
the judgment
yes.
has to be removed, which has not been removed.
No,
That is what we find
no,
from your.
yes, my lord. Basis
So
of,
this judgment on its bare reading
Yes.
shows that it was only to deal with a particular situation of a vacuum.
Yes, my lord. And how the vacuum is to be filled, my lord?
So tell us,
Guidelines are laid down.
extend it.
Please, my lord.
How do you extend it beyond
Yes.
the framing of the law?
Yes.
That this has to be the norm and
It,
the
my lord,
parliament
yeah,
has no
yes.
discretion.
No, Parliament has the discretion so long as it does not leave exclusively in the hand of the
This is
executive.
your sheet anchor.
Sorry, my lord.
This judgment is your sheet anchor.
Yes, my lord.
It
Yes.
says that Chief Justice should be there.
Yes. I'm not saying Chief Justice, my lord. There has to be, my lord. What I am saying is it cannot be with the hands of the executive exclusively. What the Parliament does, my lord, there are various committee reports on various things. But it cannot be in the hands of the executive. As Section 7 says, Prime Minister, a minister nominated by the Prime Minister and leader of opposition. Means, my lord, it is in the hands of the executive and executive alone. I am not saying that Lordship would issue a mandate.
You have the parliamentary debates which
Yes, I have, my lord. I will show to you, lord.
let us go to that.
It is in that.
Because it stops until the law is made by the
Yes,
parliament.
yes, my lord.
So what did the parliament consider? How was this judgment considered by the parliament?
Please,
Was
lordship,
that-
would your lordship permit me to place that, my lord? Just, my lord, may I read just two more paragraphs and then come to the constituent and the parliamentary debates, my lord. Para 301 and 3 by Justice, my lord Justice Joseph. Yes. However, para 301, however, it is equally clear that 324 has a unique background. The founding fathers clearly contemplated a law and did not intend the executive exclusively calling the shots in the matter of appointment of. Lord, so, my lord, the law which your lordships had declared, such law made by the parliament cannot be, which gives exclusive power to the executive. It does not meet the test of this judgment. It does not meet the test, the ratio laid down by this, which is called out from the Constituent Assembly debates and the various reports of the before and after the Constituent Assembly. And similarly, my lord,